Welcome to Kaumudy Global. Familial relationship may take the form of domestic, unmarried partnerships or queer relationships, the Supreme Court has observed, while noting that an atypical manifestation of a family unit is as real as its traditional counterpart and deserves protection under the law. The predominant understanding of the concept of a family, both in the law and in society, is that it consists of a single, unchanging unit with a mother, a father, and their children. This assumption ignores both the many circumstances which may lead to a change in one's familial structure and the fact that many families do not conform to this expectation to begin with. Familial relationships may take the form of domestic, unmarried partnerships or queer relationship, a bench of Justices D.Y. Chandrachud and A.S. Bopanna said in an order uploaded on Sunday. The observations are significant as activists have been raising the issue of recognizing LGBT marriages and civil unions as well as allowing live-in couples to adopt after the Apex Court decriminalized homosexuality in 2018. The Apex Court made the remarks in its verdict that held that a working woman cannot be denied her statutory right to maternity leave for her biological child only because her husband has 2 children from a previous marriage and she had availed the leave to take care of one of them. The bench said that a household may be a single-parent household for any number of reasons, including the death of a spouse, separation, or divorce. Similarly, the guardians and caretakers who traditionally occupy the roles of the mother and the father of children may change with remarriage, adoption, or fostering, it said. It said that these manifestations of love and families may not be typical, but they are as real as their traditional counterparts, and such atypical manifestations of the family unit are equally deserving not only of protection under the law, but also of the benefits available under social welfare legislation. The black letter of the law must not be relied upon to disadvantage families which are different from traditional ones. The same undoubtedly holds true for women who take on the role of motherhood in ways that may not find a place in the popular imagination, said Justice Chandrachud, who penned down the verdict on behalf of the bench. The bench said that unless a purposive interpretation were to be adopted in the present case, the object and intent of the grant of maternity leave would simply be defeated. The grant of maternity leave under rules of 1972 is intended to facilitate the continuance of women in the workplace. It's a harsh reality that for such provisions, many women would be compelled by social circumstances to give up work on the birth of a child if they are not granted leave and other facilitative measures, it said. The fact that the appellant's spouse had 2 biological children from his first marriage would not impinge upon the entitlement of the appellant to avail maternity leave for her sole biological child. The fact that she was granted child care leave in respect of the 2 biological children born to her spouse from an earlier marriage may be a matter on which a compassionate view was taken by the authorities at the relevant time, it said. The bench said that gendered roles assigned to women and societal expectation means that women are always pressed upon to take a disproportionate burden of childcare work. It referred to a time-use survey conducted by the Organization for Economic Cooperation and Development and stated that women in India currently spend up to 352 minutes per day on unpaid work, 577% more than the time spent by men, and time spent in unpaid work includes childcare. In this context, the support of care work through benefits such as maternity leave, paternity leave, or childcare leave availed by both parents, by the state, and other employers is essential. Although certain provisions of the rules of 1972 have enabled women to enter the paid workforce, women continue to bear the primary responsibility for childcare. The grant of childcare leave to the appellant cannot be used to disentitle her to maternity leave under Rule 43 of the Rules of 1972, it said. This is Anjana signing off. Do like and share this video. For further updates, subscribe to Kaumudy Global.